From the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Today's subject is pretrial publicity of celebrities in criminal cases. Can an impartial jury be selected? I'm sure our viewers are not surprised that we'd be addressing this subject at this time with the famous O.J. Simpson case underway, and there have been many other cases such as the Tyson case and others. And so we've invited an attorney to come today to talk about this, not in the sense that so much of the publicity has been put forth on details of a particular case and what evidence there may or may not be, but dealing with the publicity that surrounds those kind of cases. I am so pleased to welcome my friend to the program, Glenn Walker, who is a former Kootenai County prosecutor, and he's also really one of the outstanding defense attorneys today in the state of Idaho. He's been extremely successful in both sides of cases as a prosecutor and now as a defense attorney, and has had a very successful rate of either convictions and now as defending individuals, and so he understands the process. Glenn, as it has been in the past, it's very good to have you back on the program.
Happy to be here.
You and I have talked on a number of occasions about these kind of subjects, and certainly recently we've talked about this. Let's start out by informing our viewers about, even before we get into the issue of celebrities, there are a lot of complications in preparing for a major criminal trial, like a murder trial, both for the prosecution and the defense. Would you just share with our viewers some of those challenges that one has, even if it does not receive a lot of publicity?
Well, every case is a challenge to one degree or another, but where there is a high-profile case, whether the defendant is a celebrity or there's something particularly serious or egregious about the facts that make it high-profile, everything is heightened. The tension is much, much greater. You want to be that much more careful. Truly, the juries expect it to be something really significant from both sides if it's a high-profile case. So, but whether it's high-profile or not, you have to be ready, and preparation is what lays the groundwork for a successful trial, prosecution, or defense.
In cases where they're very serious, maybe even the capital offense could be involved, is it not true that both the Office of Prosecution and the Defense Office, they use a lot more personnel than they used to? There's a lot more preparation of looking at witnesses and on both sides. Or we hear a lot about even experts coming in to help with the selection of the jury. Just respond to that about, again, preparation. Have we gone overboard, or is that very good for the judicial system to have that even more detailed preparation?
Well, everybody has a right. Everyone has a right to a fair trial. Everyone has a right to the most vigorous defense that they can get. And if the public defender is trying a case, the public defender is usually going to be very limited in his resources or her resources to do those things. If you've got private counsel, they, depending upon the money that's available, they will put more and more preparation into it. But prosecutors, wherever they are, the more significance the case has, the more preparation they're going to put into it. If you've got a very high-profile case and the prosecutor has the opportunity to bring in any kind of a consultant, he or she's going to do that. And defense attorney will do the same thing. The kinds of cases that I, as a local defense attorney, will handle, in many, many years of experience, I've never had the blessing of being able to go out and hire a consultant to help me in selecting a jury. So what I have to do is what defense attorneys have done since the beginning of trials, is you use your gut instincts and a lifetime of experience in dealing with people, understanding issues, understanding how issues affect people. You just put that much more time on it. If you're looking at a case like Tyson's or O.J. Simpson's, that's a case that ties up prosecutors for weeks and months. Not one, but many. In the Tyson case, there was one prosecutor that got all the publicity. but there were several behind the scenes that were assisting him on a full-time basis. And in O.J. Simpson's case, we see 2 lead prosecutors, 1 lead, 1 secondary, but there are dozens other behind the scenes that are helping virtually on a full-time basis. And of course you've got many, many investigators within the prosecutor's office, within the sheriff's office and the city police, within the coroner's office, and sometimes private investigators that prosecutors hire to assist. And of course the defense team will be doing the same thing, and it's limited by resources. In most cases, frankly, the defense does not have the ability to put forward those kinds of efforts. And so they are oftentimes challenging the state's case rather than putting on their own. In these big high-profile cases where there is money for defense, then the defense itself is going out and digging up evidence, excuse me, and trying to put on their own case.
Well, we've talked some about if you have a local case where it's maybe a really vicious type of crime and someone's accused but presumed innocent until proven guilty, you may have a lot of publicity in that area. But we're going to get back to this in a minute. But the way a judge deals with that, or the selection of a jury, or moving outside of that particular region to get a jury, is really different from an O.J. Simpson case where it's even international, and it's
Yes.
Every media of the world has covered that. Let's talk about that kind of case first, Simpson. And Tyson was not even the amount of publicity. I've never seen a case that has had the attention that this particular case has, and there's a lot of understanding of why that might happen. But with this extensive media coverage, and there is something called freedom of the press, which is important, let's put you in that role for a moment, and let's look at it from the perspective of a defense attorney or a prosecutor, which you can easily do since you've performed both of those duties. What kind of role does a judge have in that situation? In this case, there was tremendous amount of information that got out, and appears to have come from both defense and prosecution. And once it's the information is out, and cannot bring it back. As our title of our program said today, what can one do to get an impartial jury? I'll even ask another way. Is it possible to have an impartial jury?
That's a long question, Tony. First of all, this is a judge's dream case. It's his career case. No judge has ever sat on a case. No prosecutor has ever prosecuted or defense ever defended a case like this. It's the most high-profile case in American history, and probably in the history of the modern world. It's the most high-profile case, period. So this judge can't treat it like any other case he's ever treated. He is breaking fresh ground every single day. And while he has precedents to go on to guide him in things like pretrial publicity, at the same time you have to recognize the tremendous hunger and thirst that the public has for knowledge on this kind of thing. So many people are saying, I don't want to hear anymore, I'm sick of it. Yet the networks and stations and newspapers are reticent to not cover it because if they don't, they lose ratings.
So it's skyrocket if they cover it. Huh?
Everybody says, that's enough, I don't want to hear anymore. But if one station turns it off, then everybody flocks to the other stations that has it. So it'll be the most watched trial, as well as it's been high profile already.
But if I can interrupt to say, so many witnesses have been interviewed by, in particular tabloids, and so many pieces of evidence have been seen, and of course the pre-trial motions and so forth have been so publicized, and the preliminary hearing is almost like a trial in the preliminary hearing.
Yes.
Then if you could find 12 women and men, or 13, that had not heard about it, would they have the judgment to make a decision if they were that isolated from society?
Well, of course, it's possible that somebody could have, but so much time has passed from the incidents occurring until the actual time of the trial that it's pretty hard to be away from society so that you don't hear of that. You have to be a moron, probably, not to understand what's going on with regard to this case. So the publicity is there. A judge has to recognize it is there. We got to deal with it. So how does he deal with it? Well, first of all, as you indicated, you recognize the right of the people to know, and that leads to the right of the free press. And that's fundamental to our society, and you can't cut that out any more than you cut anything out. More important than the freedom of the press and the freedom of information is the right of a defendant to have a fair trial. So you have that balancing act. There's always tension between my right as a defendant to a free trial or a fair trial, the public's right to a fair trial for the state, in other words, and the press. The fair trial has to come first. So we are always cognizant of that, and so there could reach a time that the judge is going to say, enough, we can't allow it. But in this particular case, the press is going to write about it every day anyway, and there will be leaks. There's what you just can't, in a free society, shut down the press. You just can't do it. So that's why so much has gotten out. Somebody connected with it somehow is going to hear something, and so they will print and film innuendo and rumor if they don't have facts. That's the way the world works.
Another thing that really complicates it, if you were the prosecutor in this case and you had one or two really key witnesses that had some, what you believe, damaging evidence on the defendant, but yet that witness has sold their story in advance to some media, the defense is going to take your witness apart, aren't they?
Well, in reality, as I understand it from observing, that's already happened in the Simpson case. There are already witnesses who have done just that, and the prosecution is now faced with this dilemma and in fact has decided, as I understand, not to use some witnesses who would have been very important prosecution witnesses. That's a shame, but there wasn't anything apparently that could be done about it.
There's been so much initiated out of this case, as you so rightly said. There is a bill introduced in California, it's my understanding, to absolutely prevent a potential witness from selling their story until, I believe it's something like a year after the trial is over. Do you think that is proper or that is constitutional?
Well, I think it can be done. I think that something like that could pass constitutional muster because, again, we have to get back to the right of the defendant to have a fair trial, the right of the state, the prosecution, to have a fair trial. Remember, these cases are brought in the name, this one, in the name of the people of the state of California. The people have a right to a fair trial just as much as the defendant. If a witness goes out and sells his story, therefore damaging his own credibility, then the people, the other side of the trial, the two people here, the defendant and there's the people. People have lost their chance to a fair trial to some degree. Now, I guess the fundamental question is, how does that damage the prosecution if a witness does that? Well, a defense attorney is going to try to show the jury that this witness is not a fair and impartial, unbiased witness. This person has a stake. This person, in fact, had such a stake that he or she recognized that it has monetary value and went out and sold it. This is a tainted individual who is a person for hire. That's what the defense attorney is going to try to show. I think if I were a prosecutor, I would, in most cases, want to try to use that witness anyway. And I'm sure that the prosecutors here have gone over this hours and hours on end, and if I know anything about it based upon my own experiences with meetings with prosecutors, they probably had 15, 20 prosecutors at a time kicking around how damaging it would have been. I'd say that you probably got weeks of time cumulative added on that one question of whether a certain witness is going to be used or not because it's tainted.
I want to focus in on selection of the jury.
Okay.
And your ideas that I've already discussed with you are really excellent in this area. For our viewers who may not have followed the judicial system closely for a very long time in our country, both the prosecution and defense were invited, or rather encouraged to, as 12 potential jurors set there for questioning, to ask lots of questions to each individual potential juror to see where they're at and what bias they might have. Now we've moved more to asking questions that are a question that's general to the jury, or maybe, it's my understanding, you raise your hand if you have certain things. It's not so focused, but rather the whole jury. How is that going to fit in it? I guess I have a two-part question. One, what do you think about these two different ways of selecting a jury? And number two, how can you do that in such a famous case when the whole key point is that potential individual juror biased from all this information? I know it's an involved question.
Well, most judges have a good deal of say, a good deal of leeway about what kind of jury selection they're going to allow. In the federal system, and most state courts have been going to having the judge ask a good number of the questions, in some cases having the judge ask all of the questions of the jury panelist. I think that it defeats the opportunity to have a fair trial for either side, and I think it's unfortunate that we have gone that far. but I can understand why judges want to be able to move the system along. We have basically two ways that it works, unless the judge asks all the questions, which would make 3 ways, and those 2 are individual voir dire, or individual questioning, in other words, where the prosecutor stands up, goes first, asks questions of one particular juror, panelist, focuses on him or her, and continues to question and answer. That might go on all day or longer with a particular person. In this particular case, I think the jury selection is going to go on for quite some time. I think it will be going that way. When this airs, the people are going to know, because it presumably would already have started. That's individual voir dire or individual questioning. And that can be done outside the presence of the other jury panelist, or it can be with the other jury panelists there listening to the question and answers. Many people in the system feel that even having the other panelist hear the question and answers, that taints how they will answer. And to some degree it does. With some people on that panel, it will. Every time you have it to some degree. But where individual voir dire is permitted, the judges usually will have it in front of the panel. I don't know in this case. They may isolate them and then zero in on them so nobody else can be tainted by it. And the other way, what we call a struck jury system, is where the prosecutor stands up, questions the entire panel at once. And he's speaking to maybe 100 people at once. And in this case, the panel will be much larger than that. But he's speaking to all these people at once. And how are you going to get a good question and answer session where I'm asking a question, there's 100 people out there that may or may not choose to answer? While most people, we know, are reticent to answer and stand up and draw attention to themselves. So many people who would answer a question if it were one-on-one will not, and they sit quiet with their emotions.
In this case being this famous and everyone hearing this much information, isn't the judge put in the position of almost having to allow attorneys to zero in on individuals because all the problems you're saying? Otherwise you could wind up with people in that jury that, because they remain silent and so forth, that would have their minds made up and maybe in different directions, but you would not be able to find that information unless you had a direct examination.
Well, your fundamental question is, can a fair jury be found? And I believe the answer is yes, but it won't be found. And we would never even know if it could be found if you didn't have individual juror questioning. You have to have it in a case that is so widespread with publicity. You must have it, because there are people in every community that secretly would love to sit on a jury. And that person, in many cases, is not the person you want. In most cases, what you really want is someone who really doesn't want to do that, who has other things to do with his life or her life. But that person, everybody's got emotions and everybody has bias. You know, we can't be without prejudice. It's what we do with bias or prejudice is what's fundamental. And so if a person has a feeling that this defendant may have committed the act, well, that doesn't mean that they can't put that feeling aside and hear the evidence fairly. How are you going to know unless you get some feeling from a question and answer session about what they're like? And even then, it's an imperfect science. And so much is my gut feeling. Does my gut tell me this person's telling me the truth? But you see, if you're not questioning the jury individually, if you're talking to 100 or more people at once, you have no idea because they're not responding at all.
You'll never find out.
You'll never find out. You would never know if you had a fair jury if you didn't do that. And in most of the cases that I ever prosecute or defend, I don't get the opportunity for individual voir dire, individual questioning. And I have to accept that that is the decision that the judges have made. I go along with that and I support it because I support the judge. But I don't like it. I just have to live with it. And in most cases, there won't be such publicity. So you're not running that kind of risk.
But this is just, it's unique in every way.
It's unique in every way.
You brought something else to my mind, and that is that you indicated that these attorneys have never had such a famous case. The judge is having to plow new ground and dealing with a lot of decisions. But would that not also hold true for potential jurors, that some individuals might find that they'd like to sit on the case that may be the most famous criminal case in our history? So does that not complicate it also? It
does complicate it. As I indicated, you'll see oftentimes people would want to sit on a jury. In this case, you'll find scores of people who would want to do it. But the problem is you'd like somebody who would be able to use logic, common sense, someone who's used to making decisions, can use good business sense, but there are very few business people who can set aside their business to sit on a jury for months. There are very few mothers who are good, common sense, logical people who can leave their young children alone. I mean, and you go across whether the person has a job or doesn't have a job, there are many reasons why they can't sit.
Because this will go on for a long time.
It can go and probably will go for a long time.
And that lessens the chance of getting a representative jury of the population.
It does.
There's something else that comes to mind in this whole process, and that is there's going to be some really complex evidence, the DNA, which is just a new field, and there'll be great experts on both sides. And so isn't that another reason why it's so important to be able to question individually persons who might become jurors? Because would you not, as an attorney, want to know if a potential juror had certain kinds of concepts or ideas that would be helpful to them in trying to analyze such complex evidence?
Indeed. The questioning for a jury is first of all to find out if there's any bias that a person has toward the defendant or in favor of the defendant, or bias against the state or in favor of the state. But once you get past that, then you want to find out, okay, who is this person, this juror, or this potential juror? What do they like? What do they read? What do they think? Because again, it's all designed to find out if, while they may not have any expressed bias one way or another, they may have an inner bias in favor of one or the other, if you can just expose them to it. This case has so many issues that are so fundamentally important, so significant, in so many cases just really scientific, that you got to dig into the person, their mind and their consciousness to see where they are.
And with such incredible, outstanding attorneys. I mean, I've never seen such a defense team ever put together.
It's a brilliant team.
And then there's some brilliant individuals on the prosecution. That is even another argument possibly why, if they were given that opportunity, and by the time this airs they may have, because we're doing this show early, that they would also be able to pick up with this kind of brilliance they have some of those characteristics you talked about in jurors. I want to move on to something else that has a relationship with this. Many of our viewers outside of Idaho will not know that you've had some of the most high-profile cases in North Idaho. You had cases that when you were a prosecutor that dealt with bombings and so forth, and some hate group movements, and you've had, as a defense attorney, some cases that received a lot of publicity. And so with that experience, as you've gone in the courtroom and you have been in the process of selecting potential jurors, this is one of the most fundamental questions for this program in relation to these famous cases. When you question a potential juror and they indicate to you that they know a lot about the case, but they convince you they have not made up their mind, do you find as the case proceeds that, like this could be true in the Simpson case, that individuals that, even though they think that they're impartial, and as they proceed through that process, that they may move one way or the other because they truly listen carefully to the evidence? Can a well-presented case by the defense or the prosecution move someone who might have in their subconscious almost a bias, and that good presentation removes that?
Yes. We always hear that the purpose of the jury selection is to select an impartial jury. The question, can an impartial jury be found? But you got to know, and I think probably most people do when they think about it, the prosecution is not trying to find an impartial jury, and the defense attorney is not trying to find an impartial jury. As a prosecutor, I wanted to find 12 people who would lean my way. Now, I'm not going to get them, because the defense attorney is trying to find 12 people who will lean his way or her way. She's not going to get them either. And what we do is then we find that jury that's somewhere in the middle. But I'm trying to find them my way, she's trying to find them her way, and that's how we end up with people in the middle, because we're both pulling. Mm-hmm. And we can excuse people for cause if we can find that pure bias, and we can also excuse people for what we call peremptory challenges, just because our gut tells us we don't like this person, we don't want this person on there, or we don't think they like us. So we're really trying to find people who have biases our way. So that's what we're trying to do, and we end up accepting people, not because we want them, but because we think that they're not really against us. That's how we find that impartial jury.
And
it's a tug of war.
And the judge helps with that too.
The judge helps with that throughout, and that way we are finding those emotions. So we try, as the case moves along, to move those emotions in those people. We have 12 people left on the jury when that selection is done, full of emotions. And we remember what they've said and what they've done, and we indeed try to play to them.
And it must have some real effectiveness, because I would assume that in most famous cases, the counsel sits down in advance and assumes that there is someone on that jury, maybe in their direction, and the other side says someone that they're more pleased with. But in the end, they do reach many times a unanimous decision, and therefore there must be some movement.
They make unanimous decisions almost all the time. If they don't, they have a hung jury, and it gets set over to a later time. But you get unanimous juries almost all the time. In criminal cases, you have to have unanimous juries. So, yeah.
But this is so unique in so many ways. I wanted to get your reaction to this. There are so many individuals, with O.J. Simpson being such a famous person, and he's been a hero in the sports world and so forth. And since that is so unique, do you believe that this case may be one of the most difficult that we've ever had to find 12 women and men that can reach a unanimous decision, since it only takes one to make the decision?
I think it's going to be very, very tough to get a unanimous decision. The prosecutor will leave no stone unturned in this case, and the defense attorney will leave no stone unturned. It'll take a long, long time to try it. I think ultimately we will get a decision. The prosecutor's decision to not seek the death penalty gives us a much better chance of getting a decision. I don't think we would have gotten a decision, or I think we may have gotten a defense verdict if that possibility of a death penalty were there. And while many women's groups didn't want to see the prosecutor do that, I think the prosecutor had to do that, because the prosecutor has to be able to get a decision, has to be able to get a conviction if he believes justice requires it.
We're about out of time, but another critical point in this trial for people to watch is there's an incredible amount of evidence that's attempted to be admitted. So the judge's rulings on what does and does not get before the jury will also be crucial throughout this process, will it not?
Indeed, indeed.
Yes. Well, Glenn, I wish we had more time. You've just been so interesting, and I'm sure our viewers have found this most helpful as we proceed on through this case, but all the cases in America and how this whole process works. Thank you very much.
You bet.
Ladies and gentlemen, our guest has been Glenn Walker, a well-known defense attorney in Idaho and the former prosecuting attorney of Kootenai County, Idaho. I know that you have found this program most informative, and I would like to invite you to be with us again next week at this same time when we will discuss yet another issue. Until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.